Mr. Chairman, I rise in opposition to the amendment.
The gentleman is recognized for 5 minutes.
Mr. Chairman, the effect of this amendment is to carve out a $1.5 trillion hunting preserve for strike suit lawyers. It would exempt from the protections for plaintiffs who are class members, plaintiffs who are involved in actions related to derivatives. Presumably, in order to protect the citizens of Orange County, California, the gentleman from Michigan would make sure that our legislation would not be available to provide for people in Orange County a plaintiff steering committee, so that the plaintiff class has a means to protect themselves against abusive practices. There would be no court-appointed guardian for members of the class if they happen to be suing in relation to Orange County. There would be no ban on professional plaintiffs. There would be no ban on bonus payments to preferred plaintiffs so that some members of the class could be discriminated against. All the protections in our bill would be unavailable. There's also an incredible non sequitur in the argument that I just heard, and that is that Barings and Orange County and Procter & Gamble's problems with derivatives and Gibson Greetings' problems with derivatives, all of these things wouldn't have happened if only we had the present strike suit system in place. But of course we do have the present strike suit system in place, and all of these things happened. What we are seeking to do is prevent fraudulent abuse using the securities laws. Now, our existing securities laws are targeted at abusive practices, devices to deceive, manipulate, and defraud. For the first time, what the gentleman from Massachusetts would be doing is shifting us away from focusing on bad practices and saying that we're only going to focus on these bad practices if they involve certain kinds of securities, and we will discriminate from one kind of security to another. It would be an incredible hodgepodge, unmanageable for our nation's capital markets. Now, it isn't as if we have to deal with this issue at the 11th hour with a floor amendment. We've actually had hearings on this subject. The Senate Banking Committee had extensive hearings on derivatives and on their role in Orange County. Alan Greenspan, the chairman of the Federal Reserve System, testified. Arthur Levitt, the chairman of the Securities and Exchange Commission, testified. Here's what they said. Arthur Levitt, quote, "It would be a grave error to demonize derivatives and blame them for the loss in Orange County. Derivatives are not inherently bad or good. They are a bit like electricity, dangerous if mishandled, but bearing the potential to do tremendous good." Alan Greenspan, quote, "It would be a serious mistake to respond to these developments by singling out derivative instruments for special regulatory treatment." The chairman of the Federal Reserve said it would be a serious mistake to pass the gentleman from Massachusetts amendment because the Markey Amendment singles out derivatives for special treatment and special legal status in 10b-5 actions. It would create a separate legal status for the treatment of derivatives. Furthermore, there's no reason Congress should permit abusive litigation to continue if a derivative is involved. What we're after here with this legislation is the prevention of abusive practices. Why would we want those abusive practices to go on if derivatives were involved? It makes no sense at all. Congress would defeat its purpose if it allowed abusive lawsuits to continue in one special area of securities transactions. Congress should end abusive securities transactions, Congress should end abusive securities litigation, regardless of the particular type of transaction that was involved. I urge the defeat of this ill-considered amendment. I'd be pleased to yield.
Just very quickly, to ask the gentleman if he concurs with me, two examples that have been prominently used in this particular debate on this amendment, Barings and Orange County. If you apply the requirements of Cyanar under this particular statute that we're discussing, the defendant directly or indirectly made a fraudulent statement, the defendant possessed the intention to deceive, manipulate, or defraud, the defendant made such fraudulent statement knowingly or recklessly. As we know the facts of these two particular cases, in these two particular cases, they would not be afforded any of the benefits under the statute that we're debating, which is aimed at stopping frivolous lawsuits. Is that the gentleman's understanding?
That's exactly right. What we'd be doing by passing this amendment would be opening the door for frivolous lawsuits in a particular type of case. And ironically, there would even be new issues to litigate. Now we could litigate the question of whether a derivative product was involved or not. Whether it was peripheral to the transaction, whether it was central to the transaction, whether it was really a derivative or not, all of this is rather abstruse and in any case irrelevant to what we're trying to do right here.